Today on Bench Briefs, we're looking at a landmark Supreme Court of Canada case that explores the tricky balance between federal and provincial powers in workplace safety. On this episode, we dive into Bell Canada v. Quebec, a 1988 decision that helps define who gets to regulate occupational health and safety for federally regulated companies. So, what's the story? Bell Canada, as many Canadians know, is a major telecommunications company regulated by the federal government. That means it's governed by federal laws under the Constitution rather than provincial laws. But the province of Quebec, through its Commission de la Santé et de la Sécurité du Travail, known as the CSST, wanted to apply its provincial workplace health and safety regulations to Bell Canada employees working in Quebec. This set the stage for a legal tug of war. On one hand, Bell Canada argued that because it's federally regulated, only federal laws should apply to its workplace conditions. On the other hand, Quebec's CSST insisted that provincial occupational health and safety rules must still protect workers within the province, even if the employer is federally regulated. The heart of the dispute was about jurisdiction. Can Quebec's provincial health and safety laws apply to a federally regulated employer? More broadly, this raised a constitutional question about the division of powers laid out in the Constitution Act of 1867. The Constitution splits responsibilities between federal and provincial governments, but sometimes the lines get blurry, especially in areas like workplace safety, where both levels of government have interests. Let's break down the key facts. Bell Canada operates across Canada and is federally regulated under the Canadian Constitution. The CSST is a Quebec provincial body responsible for enforcing workplace health and safety laws in Quebec. The CSST wanted Bell Canada employees working in Quebec to be covered by its provincial rules, including inspections and enforcement. Bell Canada resisted, arguing that because it's a federal undertaking, provincial laws should not apply to it. The case made its way to the Supreme Court of Canada, where justices had to decide whether Quebec's CSST had the authority to regulate Bell Canada's workplace safety practices. This meant interpreting the constitutional division of powers. Section 91 grants the federal government jurisdiction over things like telecommunications, while Section 92 gives provinces power over matters such as property and civil rights, which includes workplace safety. The Supreme Court's decision was significant because it clarified how provincial laws apply to federally regulated undertakings. The court ruled that Quebec's occupational health and safety laws through the CSST do indeed apply to Bell Canada employees in Quebec. The reasoning was that workplace safety is a matter of paramount importance to provinces, and that the provincial regulations do not impair the federal undertaking's core functions. In other words, provinces can regulate workplace health and safety for federally regulated employers as long as the provincial laws don't interfere with the essential federal jurisdiction. Why does this matter? This case helped set a precedent for how federal and provincial powers interact in the workplace safety context. It confirmed that provinces have a legitimate role in protecting workers' health and safety, even when those workers are employed by federally regulated companies. This decision strikes a balance between respecting federal jurisdiction over certain industries and ensuring that employees receive proper protection under provincial health and safety regimes. Bell Canada v. Quebec is often cited in Canadian constitutional law as an important example of cooperative federalism, where federal and provincial governments share responsibility in certain areas. It also reassures workers that their safety won't fall through jurisdictional cracks just because their employer is federally regulated. Thanks for listening to Bench Briefs. Join us next time for another deep dive into a case that shapes Canadian law.